Welcome to the Parham Estate Law Podcast.
Welcome to the Parham Estate Law Podcast with Mike Parham. Mike is the founder of Parham Estate Law and a Tennessee estate planning attorney who helps individuals, families, and business owners protect their assets, plan for the future, and avoid unnecessary complications. I'm Evan Mack, and today we're talking about whether or not you actually need a trust and if a will is enough. Mike, welcome back.
Thank you. Good to be here.
So, Mike, when someone starts thinking about estate planning for the first time, what usually makes them ask whether they need a trust or just a will?
Well, there's several factors that I look at. The number one factor is, do they own real estate in multiple states? If you do, then you're almost assured that a living trust is for you, because it's going to help you not only avoid probate in your home state, but also in 2 or 3 other states possibly. The other factor that I look at is the person's age. I believe that as people get older, the more valuable a living trust can be for them. The reason for this is not only can it help them avoid probate, but it also makes it much easier for the next generation to step in and begin administering their assets for them. They don't have to rely on powers of attorney, and they certainly don't have to wait until the person dies like you would have to do with a will. Now, living trusts aren't for everybody. They're more expensive than wills, and some people I don't think need them. If you are a young couple that has young children, their main focus is to make sure their children are taken care of, which is they need to have a guardian appointed. You can do this in the will. In fact, that's how you're supposed to do it in your will. They also want to make provision for the children. They don't want them to receive the money all at 18 like they would otherwise. They want to have a trust for the children so that the assets can be administered by a third party until they reach a certain age. You can do that in a will. Now, with a young couple, probably in their 20s, a lot of times they don't have a lot of money, and the likelihood of both of them passing away within the next 20 years is very low. So you have to look at the cost-benefit analysis on whether they need to spend the extra money on a trust. I don't usually recommend that they do. Sometimes they will insist. They want to have a trust because they just want the ease of administration later. But the factors I look at mostly are the different states that you own real estate in and the age and health of the person, especially if that person is a widow or widower and they have no spouse.
So for someone who has never gone through this process before, what does a will actually do in the state of Tennessee?
The will is not effective until a court states that it's officially the person's document. There are a lot of things with wills that can cause issues. Sometimes they're not executed properly. In Tennessee, you have to have 2 witnesses that aren't related to the person who are over age 18. Sometimes people think, well, I had it notarized. Well, that's not good enough. Also, if you have it witnessed, Tennessee allows you to use what's known as a self-proving affidavit that can be presented with the will. If you don't have that self-proving affidavit, the witnesses are going to have to appear in court to testify. Now, if this will has been more than 10 years old, it might be kind of difficult to find these people to have them testify. So that's some issues that you have with wills. You can, of course, there's ways you can avoid probate that I can recommend.
So what does a revocable trust allow someone to do to a will that a will cannot?
Well, a will cannot take effect before the person dies. And then, it's not effective until a court makes it official. A living trust takes effect immediately upon signing. Now, for it to be fully effective, you have to fund it. And by funding, I mean you transfer your assets to the trust. You retitle your house, do a deed into the trust. You change the ownership of your bank accounts to the trust. If you do this, then at your death, the assets are already in that trust and they don't have to pass through the probate process.
So Many people think that trusts are only useful for the very wealthy families. Who can actually benefit from having a trust, though, Mike?
Well, that's a common misconception, and I don't agree with it. I feel that a living trust could be more beneficial for somebody with a smaller estate. If you have $1 million estate and you have to pay $10,000 in probate costs, that's a very small percentage of your estate. If you have $100,000 estate and you have to pay $10,000 for probate, you've already spent 10% of your estate just on probate costs. A trust can help you avoid that. So people say, well, I don't have enough money for a trust. And I say, how much money you have has very little to do with whether a trust would be beneficial for you.
Mm. Probate comes up a lot in these conversations, Mike. How does the probate process affect the decision between using a will and using a trust?
Well, there are several different issues that would come into play when avoiding probate. One that's becoming more and more common all the time is family conflict. A lot of more families than you could imagine are just waiting for the parent to die before the lid just completely blows off. They're holding it together until mom passes away, but when mom goes, it's Katie bar the door. And with the probate process, if you have conflict, probate process is perfect for that situation. If you have somebody who wants to cause problems, all they have to do is file a claim, file a challenge. They don't even have to hire a lawyer sometimes for these things. With a trust, you're keeping it out of the court system. And by keeping it out of the court system, you're making it much more difficult for somebody who wants to cause problems to challenge something. If they want to challenge a trust, they have to file their own lawsuit, hire their own lawyer, spend their money to challenge it. And a lot of times that discourages people from going forward with it.
Mm. Are there situations where a will may realistically be all someone needs, Mike?
Yeah, I think so. Especially with young couples, I think most of the time they just need their bases covered. Make sure their children are taken care of. If they pass away, make sure that their spouse has the ability to sign documents on their behalf if something happens to them, which they could do through a power of attorney. Most banks and other institutions are going to honor a power of attorney in favor of a person's spouse. Those documents are very important. They're not expensive, but they're important. I had one client who did not do a financial power of attorney. He ended up having a severe heart attack. They had their house on the market. They had a contract, but they could not close on this sale because he wasn't able to sign the deed because he was a co-owner. And his wife was not able to sell the house because she didn't have the authority to sign his name because he'd never done a power of attorney. But those types of things are the bases that you need to have, which in combination with the will, I think would be sufficient for some people. You have to talk to the people individually and find out their situation to know whether that would be enough or not, though.
Wow. So, Mike, before we kind of wrap things up, can you share an example of a family situation where a trust created advantages or maybe flexibility that would have been difficult to accomplish with only a will?
I have uh, it's going on right now. This lady just passed away just a few days ago. She executed a living trust. She placed her house in the trust. She has all her accounts in the trust. She has the trust named as beneficiaries. Now she has multiple, and she was never married and had no children. With a trust, she was able to name charities that she wanted to remember. She was able to divide. She didn't have an equal division. She had some nieces and nephews. She had some great nieces and nephews, and she had different amounts for all of them. With a living trust, she made the trust the beneficiary. So all the money passed into the trust. So when it's time to give 10% to this person, 25% to this person, you didn't have to go through and do beneficiary designations on all her multiple accounts that she had. All you had to do is make the trust the beneficiary, and then the trust divided everything out. Everything just went in the trust, and then the trustee just divided out according to her wishes. Made it much more simple than it would have been by trying to utilize beneficiary designations in that situation.
Wow. Good stuff. Mike, thank you so much for your time.
Thank you.
All right. That's it for today's episode of the Parham Estate Law Podcast with Mike Parham. If you'd like to learn more about wills, trust, or creating an estate plan that fits your family and your goals, visit parhamestatelaw.com. Thank you for listening. Don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode. And we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.